She just sees Cameron on there. She just starts crying.
Recording in progress. Record.
Good morning. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over the session. Is there a Derek Graham present in the Zoom environment? Is there a Derek Graham present? If so, please unmute yourself and say your name. Court will call the case of the people of the state of Michigan versus Angela Marie Hayes, case number 20F1-1359.
Good morning, Your Honor. Ashley Lundy for the people.
Good morning, Ms. Lundy.
Good morning, Your Honor. Danian Woodson on behalf of Ms. Hayes.
Good morning, Ms. Whitson. Good morning, Ms. Hayes. How are you? Is she present?
I didn't see her listed in the participants, Your Honor.
Then I don't think we're ready to go yet if she's not here, are we?
No, Your Honor. I don't think she's here. She's,
No, but as soon as she logs in, Your Honor, we'll be ready to call the case.
Okay, thank you very much.
thank you.
Court will call the case of the people of the state of Michigan versus Kyle Robert Head, 20 F2 1469.
Good morning, Your Honor. Elizabeth Andrews, Assistant Spring. On behalf of the
Good morning, Ms. Andre.
Good morning, Your Honor. Mary Mahoney on behalf of the defendant, Kyle Robert Head.
Good morning, Mr. Head and Ms. Mahoney. They're going to need the table. They're conducting an exam. Good morning, everyone. We are back here today on for the conclusion of a preliminary examination, which we already started on June 8th. So, Ms. Andre, I presume you have one more witness. I think you said you had to call.
Yes, Your Honor.
All right, you may call that witness. Are there any preliminary matters before we get started? All right, you may call your first witness or your last witness, rather.
Right. At this time, we call Detective Brian Yeager.
Thank you. You all may be seated.
Thank you.
Raise your right hand. You testify in the court, you swear or affirm to tell the truth, the whole truth, and nothing but the truth. I do. Please be seated. I need you to state and spell your full name for the record.
My name is Brian Yeager, BRIANYEAGER.
Detective Yeager, how are you currently?
Main detective with the Washington County Sheriff's Office.
And how long have you been with the Sheriff's Department?
Almost 14 years.
Back end of 2019, early 2020, were you working in capacity as a detective at the Sheriff's Department?
Yes,
And are you the officer in charge that was assigned to investigating an individual by the name of Kyle Head?
yes,
At some point in time, you received information from the victim on this case, Ms. Nakia Robinson, is that right?
yes.
And what was it that you did? What was your first steps in the investigation?
The first step, I was contacted by Corporal Mercure, who initially interviewed the victim, and he asked for my assistance with this investigation. And soon after that, I met in person with the victim. Ms. Nakia Robinson.
And at some point, did you receive information regarding, I'm sorry, when you met with Ms. Robinson, you heard about all the phone calls that you've been receiving, is that right?
Yes,
And the voicemails?
yes,
And at some point, did you develop some sort of a suspect on that?
yes.
And how did you get that information?
I was forwarded an email that Grass Match had sent to Nakia Robinson. And the email had, was from the administration of that site. And in that email, it indicated that Kyle Head was the likely operator of the account that was involved with this.
And with that information, then, did you then meet with the defendant, Mr. Head?
I did,
And do you recognize him in the courtroom today?
I did.
Can you tell us where he's seated and something that he's wearing?
He's seated at the defense table. He's wearing a black dress shirt, black face mask.
Your Honor, I've asked that the record reflect the witness has identified the defendant.
Any objection? It shall so reflect.
Tell me about your.
I met with him on January 2020. He did make phone contact with him. I attempted phone contact with him, left him a voicemail. He called me back and requested that I meet with him at that address. I believe it was on Pittsburgh Street. And I went to that location and I sat down with him in residence at the kitchen table, and we talked about this investigation. And after speaking with him for a few minutes, I recognized his voice was the same voice that I heard in the voicemails that had been provided to me by Nakia Robinson.
And at that point in time, had you listened to all of the voicemails?
Yes,
And you put all of those on a disc, is that right?
I did.
And if you remember, you estimate about how many voicemails?
About 200.
Initially, did the defendant deny that he made those phone calls and voicemails?
He did. He did not make any voicemails for anybody.
It's a statement of a party opponent.
Overall,
He denied leaving any voicemails for anybody associated with grass match.
And what did you do based on that?
I played one of the voicemails that was left for Nakia, and I played it for Kyle, and he identified that it's his voice being a voicemail that he left, that he had forgotten.
He'd forgotten that he left a message.
He did. He said he had been smoking a lot of marijuana, and his memory wasn't great, so he forgot to left any voicemail.
And do you remember which call you played for him, or which voicemail?
It was one of the voicemails that referenced well,
Was it one that also involved some sort of threat? Remember?
I don't recall off the top of my head. If I could refer to my report, I know I have it in there which one I played for him.
If that would refresh your recollection, yes.
Yes. The one I played for him did not include any direct threats.
But he identified that as his voice?
Yes,
And you listened to all of them and now talked to him. Do you agree that all the calls are made by, or does the voice sound like the same on all of the calls?
yes.
Did the defendant acknowledge that he was trying to harass someone?
Yes.
And tell me about that.
Kyle told me that he had sent somebody on grass match $1,500 for promise of receiving marijuana. And after that, he had discovered that he had been scammed himself. There was some sort of fraudulent activity with that. And he had reached out to that person who we sent the money to, and he used the word control them, trying to intimidate them, and he admitted to using derogatory racial terms toward that person.
I have no further questions at this time.
thank you. Your witness, Ms. Mahoney.
Thank you, Your Honor. Good morning, sir.
Morning,
You and I have spoken before. You're aware that I'm the attorney for Kyle.
I am.
When you initially went to speak with Kyle, it's true, isn't it, that he thought you were there to speak with him about the scam that he described?
Yes,
And this was a scam that had happened to him utilizing this grass match tool?
yes,
And he described the scam to you as being consistent with what you just testified to, correct?
yes,
The communication that he spoke of by way of these voicemails and certain other messages, those were intended to address the alleged scam. Isn't that true?
yes,
based on your conversation with Mr. Head, it appeared that he believed that this scammer was in fact male. Isn't that fair?
Sure. I don't know what
I'll reference you to your
It has to get here today.
report
Tell me
where
that.
your descriptions of Kyle's description to you involved using the pronoun he.
Okay,
Do you recall that?
yes,
It's fair to assume from that he believed that the scammer was in fact a male.
yes.
Did you develop any evidence that Mr. Head and this alleged scammer had ever even met face to face in person?
No,
At the time, Mr. Head was, quote unquote, 100% sure that his communication was actually with this scammer person, correct?
I don't recall the percentage, but that's what my report indicates, but anything else.
He indicated to you that he was controlling this person and attempting to kiss him off. Is that what he said?
Yes.
You disclosed at that time didn't you, that Kyle was calling a number that belonged to a female in fact?
Yes,
And when you told him that, she was surprised, isn't that right?
yes.
A little upset.
I don't recall him being upset.
And you listened to each and every voicemail that was left.
I did.
And are you able to tell us, as you sit here right now, which of those emails you consider to be a threat or a true threat?
The voicemail?
Yes.
Yes, I mean, I have a transcript of them. I could go through and identify which ones I think are threatening.
Well, I'm not talking about threatening, I'm talking about a true threat, a threat that Mr. Head intended to carry out on an actual person.
Now, I'm gonna object to that question that this calls for really a legal conclusion of some of the elements of the offense. Really for argument, not for this witness to testify to what is a credible threat.
It's an element of the offense, number one, and number two, I'm entitled to know what evidence they considered to have constituted the true threat. Obviously, Judge, this case involves a lot of speech that is vile and offensive and reprehensible. But I need to know for purposes of defending this charge, what specific statements they consider to be a true threat. The absence of a true threat, the charge itself might stand.
And Your Honor, I don't have an objection to this witness testifying to what he just described as threatening messages. I believe that the decision to charge something that has a credible threat is really the decision of the prosecutor's office to the argument at the end. I mean, this witness can't give a legal conclusion about what a credible threat is and what he believes it is.
I agree with the prosecution that the witness can't ultimately decide what a true threat is because the prosecutor determines that. I also agree that he can look at the text messages and from what he recalls or what he has seen, be able to see what he says he thinks is a threat. And then a third part of it is that this is a charge that has many parts to it. Threat is only one piece of it. So that I don't agree with your conclusion that without a threat, it doesn't meet the level of this particular charge.
Understood, Your Honor. May I continue to inquire however as to which specific texts he believed constituted threatening threat?
You may.
As mayor, officer, detective, the question now becomes, what specific messages do you consider threatening?
May I review my report to say
Yes,
that?
please.
first one says, I transcribed it from listening to it. But the message is, I already told you, bitch, your black ass ain't smart enough to outthink me, motherfucker. If your children get raped yet, they will.
Okay. Any others?
I'm gonna see to it that you and your children starve to death.
Okay.
You're gonna starve and die before you making another fucking dollar off the site, bitch.
Okay.
During the next week, I'm gonna go onto every single account and grass match and write a review telling every single person never to send money or the cards ahead of time. You are shut down, bitch. I'm gonna make sure all them little derogatory terms won't grow. Okay, if you're not saying it, Judge?
I am okay with you not saying it. Thank you.
I'm able to see the code, so understood for purposes of exam.
You're my bitch and I'm your backup.
I'm sorry, what's the date now?
November 28th, 2019 at 7:15 p.m. Another one says, gonna find me a good tree, stretch a rope around that black neck, bitch. Another one, I'll have you swinging from a rope, N-word. Another one, pound your black ass like a bag of sand. Another one, gonna wet those big ass monkey lips and stick you to a wall, N-word. Another one, I wanna find me a good lynching tree. Another one, gonna slide it in you real slow and dry. Another one says, I can hold your weak black ass down, cock your fucking mouth open and shit into it. You want me to continue?
Yes, please. So only 2 more pages.
Hey, N-word, you ever had your shit pushed in? Oh yeah, love from the N-word homies. Gonna fuck you, boy, drop them drawers, send over. Get fucked in your N-word ass. This is the white man's world and you will perform. You exist to serve the white man. And you will perform or I will crack this whip. Another one says, gonna string you up and fuck you, boy. I think those are the end of the ones I would consider to be threatening.
You won't come on video.
Now, what you just reviewed with us isn't the entire.
Your video?
This one's video. It won't play that area up there, the courtroom
That's
seat.
correct.
This is just a transcript of certain of them that you thought were threatened or highly inappropriate, yes, we say.
Well, I think most of them are highly inappropriate. Some of them are as simple as repeatedly saying the N-word, and that was it.
during your discussion with Mr. Head, he disclosed to you that in fact, he believed that this quote unquote scammer was actually in Cameroon on the continent of Africa. Is that correct?
Yes.
In fact, Mr. Head actually showed you some earlier communications that he had had with this quote unquote scammer. Is that right?
Yes.
I'm sorry, one moment, please. I'm distracted. I need to. No.
Mm-hmm. 3062 7813. Yep. Mm-hmm. Mm-hmm. Okay. Awesome. Thank you so much. Thank you. Thank you. You're welcome. Thank you. Excellent. Thank you.
All right, I apologize for the interruption. We were having some technical difficulties up here. You may proceed.
Thank you, Ron. Detective, when you left off, I asked you whether you had actually reviewed some text messages on Kyle's device reflecting earlier conversations back and forth with this alleged scammer. Is that
I
correct?
think he referenced them when we met. I don't recall if I actually photographed them or not.
May I first witness, Ron?
Yes, you may.
Sir, in order to refresh your recollection, I'm going to show you some text messages and ask you if those are the ones that you recall seeing.
Was this part of the police report? I don't recognize this document.
I know you don't recognize the document. Do you recognize the content as being what you reviewed on Mr. Head's phone?
If you give me a moment, then it's a dozen pages.
Ms. Mahoney, have you shared these with Ms. Andery already?
I did, Your Honor.
All right, thank you.
I can tell you this is the first time I've ever seen these messages.
So Mr. Head advised you that he believed that this was all part of a scam and that his communications were with this scammer, correct?
Yes.
And what efforts did you make to investigate? Did you look at his phone or take any evidence from his phone?
Well, as far as that aspect, I was there to investigate the threats that happened in Washington County. Any scam that he was a victim of, out of my jurisdiction. He wasn't even, at that time when I spoke with him, he was in Oakland County, and the home address was in Livingston County. The other alleged party is in Africa. I don't have jurisdiction in any of them.
Well, he expressed to you that he believed that the communications he was having was with this scammer. Did you investigate anything that pertained to this scammer?
The alleged person in Cameroon?
Yes.
No.
And did you tell Mr. Head that you would not be able to investigate because this alleged person was in Africa?
I don't believe I said that. I made it very clear to him the reason that I was there was about the threatening text or the threatening voicemail that they left.
Yes, and in the discussion about those texts and voicemails, what he expressed to you was that his communications, he believed, were with another person, correct?
That's what he said, yeah.
And you indicated that you think he showed you his phone to show you some of his communications back and forth.
Well, if I remember correctly, I believe he said most of his communication had been on WhatsApp. And it looks like these are actual messages from Grassmatch, I think.
Well, Grassmatch was the website that was used between
Right.
people that message back and forth, correct?
Right.
Did you investigate the messages going back and forth on Grassmatch?
Between him and the victim in this case, yes.
And all of that, the messages that you incorporated in your report, your contention is that's all the messages that went back and forth between Mr. Head and this party, correct?
In which part?
Well, I guess that's the question. He said he was communicating with some other individual on Grassmatch and by WhatsApp. And I'm trying to understand what you did to determine the nature of those communications.
I didn't meet with him to investigate any sort of fraudulent victimization that happened to him. So that was out of my jurisdiction.
He's telling you, as far as defending against what you claim he did, he's telling you by defense that his communication, he believed, was with an entirely different person. You did not investigate that, is that correct?
I didn't investigate his communication with this alleged person in Cameroon. No.
During the course of your discussion with Mr. Head, he never once mentioned the complainant in this case. Did he? In his discussion about these communications, he never indicated that he was communicating with a female in any way, shape, or form, correct?
He didn't indicate that, no.
Based on your discussion with Mr. Head, did you develop any information that Mr. Head actually even knew who the complainant was?
No.
Did he express anything that led you to believe that he knew where she was?
No.
In fact, Mr. Head indicated that he was trolling this alleged scammer by clicking a button on the computer screen. Is that right?
He said he was trolling. I don't recall him saying by clicking a button.
What information did you develop that suggested that Mr. Head had any ability to harm the complainant physically?
Can I object to the form of the question, and again, what the question is asking this witness to testify to? This is the officer in charge of the case. His role in it is to investigate all the evidence presented to the prosecutor's office. Obviously, the ultimate decision on the question that was just asked is Your Honor at this point in time. But in terms of this witness, we can only testify to what his investigation is, not make legal conclusions.
Your Honor, I think you can testify to what his investigation is or isn't. So my question was specifically designed to extract any evidence that he obtained with respect to Mr. Head's ability to physically harm this complainant.
I believe that he can testify as to what he investigated, as to the presumption that he needs to actually do that investigation in the way that you just outlined is a different situation. So your question presupposes that there needs to be an investigation along those lines. So he can testify as to what he investigated, and if he didn't investigate that particular issue, the legal conclusion that you made about it doesn't determine what his investigation should have been. So he can answer the question as to what.
I agree with you, Judge. I'm just looking for the evidence.
I understand. You can answer what you investigated, sir. You can ask the question again.
Did you develop any evidence that Mr. Head had ever been to a location where this complainant was located?
No,
Did you develop any evidence that he even knew where she was commonly located?
no,
He didn't know her address.
no,
Did you take steps to verify any of the actual Google Voice numbers that were used to communicate back and forth in this case?
well, yes, the victim provided me her Google Voice number, and then the voicemails were extracted from her account.
So you listened to voicemails that this complainant played off of some device that she owns, and that was as far as that went.
It was played off of my work computer. There was a login to her account and access the voicemail that way.
You logged into her grass match account.
No, a Google Voice account with the voicemail for that.
And you recorded directly off of the Google Voice account with your digital recorder, correct?
Yeah.
What I'm asking is, did you make any efforts to verify the number or the source, the location of where those voicemails were coming from? Other than that was the login that you used for the complaint.
Well, the origin, according to what the victim told me, I don't know if you think I can say that, but I was advised they were coming in from unknown numbers.
Did you review the metadata associated with any of the Google Voice transmissions?
Which metadata are you referring to?
Well, with each message that was communicating, there are certain computer identifiers that
Right.
tell us a lot about the source and nature of the message. Correct?
I don't think there's any necessarily anything that tells me the source of, like a phone number that's coming from in metadata.
Do you have specific training in computer forensics?
I do. I'm actually a mobile device examiner for the Washington County Sheriff's Office.
Now, initially, based on a telephone number that you had of 313-960-7132, you identified that as a number that might be involved in this investigation. Do you recall that?
I don't recall that number offhand.
Can you reference your report? And I'll try and direct you to the page. I'm looking at pages 5 and 6 of 17 in the narrative.
I'm sorry, can you repeat the phone number that you said a moment ago?
360-7132.
That phone number was left verbally in the voicemail that was left for the victim.
You actually got a search warrant to get to the bottom of what happened with that number.
Yes,
Ultimately, it directed you to a company called Text Now, Incorporated, right?
correct.
And the Text Now record was retained by you.
For a corporate.
That search warrant, you those records, and there was no documentation substantiating any contact from that number to the complainant in this case, correct?
Correct.
Did you obtain any records from Mr. Head's cell phone?
No,
Did you develop a belief as to how Mr. Head was making the contact with the complainant?
yeah, it was over telecommunications device.
But you can't tell us what number did you use to make the calls?
I can't tell you if it was a phone or voice over internet call or voice, I can't tell you that.
Is any of that information part of your investigation?
No,
Did you at least verify whether any of these calls were going through the complainant's cell phone?
no,
Is it accurate to say that in this case, all of the contact was through these Google voice numbers?
yes,
Did you make any effort to verify the complainant's password and login information?
no,
Did you subpoena any records from Gressing?
no,
There were a couple of communications that we were referenced in your report. Sorry to let the numbers stand at all. But then we have to show them to you. May I approach the witness, Your Honor?
Yes, you may.
I'm going to show you some pages taken out of the study materials, which you use yourself.
yes, I recognize this.
Where did those come from?
These were screenshots provided to me by,
And those represent messages sent from Mr. Peck to the complainant, correct? also obtain any copies of the communications from the complainant to Mr. Head?
No,
You just took what she gave you, and that was basically those pages, correct?
yeah,
And previously, one of those pages was omitted because it shows a telephone number that identifies the Mr. Heads. Is that correct?
there's a phone number on one, I can't say off memory, but. There's a phone number.
What was the method of extracting those physical photographs of the online content?
Nikia provided these to me.
Okay. She just gave you copies?
I believe, there are electronic copies, attachments to the email.
And you did nothing to verify what the accounts those were from, or even when they were sent, or by what means, correct?
Well, there's an account, you can make listed photograph on it.
I know that none of those are dated. I know that none of those are dated from our date.
No, they're not dated.
So you have no way as we sit here today of telling this court when those messages were sent to the rest.
No,
It's possible that it could have been months before the incident getting lost.
Objection, Your Honor. But it's already testified that it doesn't have personal knowledge, and he is not part of this correspondence, he received it from Ms. Robinson, who's already testified on.
We withdraw that question and ask this one instead. Did you investigate when these messages were sent?
no,
You didn't even bother to get her communication back, Mr. Head, correct?
no,
The profile used by the complainant in this case was known as the chemist. Is that correct?
I believe so.
Were you aware that you had another profile on breast match?
No,
You sat through the first part of this exam, you acknowledged that you testified that you had more than one account on breast.
I can't recall that.
You didn't take any steps to investigate any of the accounts that you had on breast.
I did not.
The records that you received from Sprint and from Text Now are actually entirely irrelevant to this case. Am I fair to say?
Yeah.
Did you develop any information that suggested that Mr. Head was actually going to cause harm to this family?
No,
His stated intention was that he was trolling this man, right?
he told me he was wrong. No.
Trying to piss him off, right?
I'm gonna object this to the phone question, as it's phrased right now, is asking the user to speculate about what was going on in the defendant's head. Was not intended, but if you want to get into specific statements of the defendant, maybe to protect the behavior, then you can do that, but right now you're asking him to speculate. I said on his own in his defense, not what was acted upon.
Excuse me, I'm
Any
sorry, Your
response?
Honor.
Your Honor, I will withdraw that question and ask a different one because I think the information was actually referenced in the detective's report.
Thank you very much.
So I should pinpoint that to him and it would probably resolve the prosecutor's objection.
Thank you.
Excuse me, I think there's a microphone muted for the lawyers. I'm really trying to hear what's happening and you can't.
The microphone isn't muted. Unfortunately, this is the best quality sound we get with the system that we have as it currently exists. Ms. Robinson. I can ask them to speak up, but I cannot fix the problem with it. It's very difficult to hear when you're online and the attorneys are speaking in the courtroom.
Okay, thank you very much.
You're very welcome.
Detective, directing your attention to page 15 of 17. It's the second full paragraph. Halfway through, maybe a third of the way through. You indicated that Kyle said his intent was to piss him off.
Yes, I see that.
During the course of your investigation, did you develop any information suggesting that that wasn't his intent?
Kind of calls for speculation, and frankly, we're at a very point where ask and answer. This witness has already testified about his entire investigation and all the things that the defendant would have wished that he did and that he didn't do. At this point, I'm objecting to asking and speculation.
Ms. Mahal,
This is a specific intent crime, and I think I'm entitled to inquire as to what information was developed that suggested what my client's actual intent was. So he's testified now to a statement that he came from the defendant, and my curiosity is to developing information that suggested to the public that my client is not being truthful and forthright, that he intended something completely different than what he told us.
And again, now we're asking the detective whether to make a decision about the credibility of the defendant in his statement without getting into the extent of.
all right,
Nothing relevant to the-
counselors, thank you. Detective, if there was any evidence in this particular case that you think negates what the defendant told you, you can testify as to that.
Okay. Well, when I spoke with the victim, she told me that she had answered one of the phone calls and told the person to stop calling her. And at that point, the phone calls continued to happen even after that communication was made verbally between them. So I would argue that as evidence that at that point he knew he wasn't talking to a man in the room.
Let me just inquire briefly as to that. She indicated that she had actually picked up the phone. Verify that in any records that you.
No,
So you got long lists of messages from quote unquote unknown callers, right?
correct?
Did you see any information suggesting that any of those calls were actually answered?
You refer to my report, I can only call. There's a
Please do.
call log included in it. No, I don't have a
Oh,
call.
I see.
These call logs that you copied and included in your report, those were all received from the complaint.
No, I don't have a call. Those are just voicemails.
You did nothing to
I don't know who it is, but it is.
you contacted Mr. Head on the phone and then subsequently went to see him. So you didn't deny him. That addresses something that was discussed during the course of the interview. I guess my question is, who proposed sitting down and having an interview?
No, we did not.
And he spoke freely with you about the subject matter that we discussed.
Yeah.
Other than what you call the denial of voicemails, you didn't hesitate to mention the question. Do you have any information on the complainant's other grass management group?
No,
You obtained absolutely no records of any kind, other than what the complainant provided.
that's correct.
You didn't interview any persons associated with grass management other than Mr. Head and the complainant, correct? May I have a motion?
Yes, you may.
When Mr. Head was discussing with you this scam, do you recall that he told you that he had had very recent communication with this scammer within 24 hours?
Doesn't sit on the.
I don't call that.
Do you recall him telling you that this scammer had threatened Mr. Head by alleging that he would advance false charges against him?
I don't call that.
And you made no notation in your report of that, correct?
No, I did not.
The entire interview was digitally recorded, right?
It was.
Thank you, Judge, that's all I have.
Thank you very much. Any further questions of this witness?
No regret.
Thank you. Thank you, Officer Yeager. Is there a motion?
Yes, Your Honor, at this time, we will provide my count 1 and 2, and count 3 follow.
Response, Ms. Mahoney?
Thank you, Your Honor. Now, the defendant opposes the prosecutor's motion based on the following particulars. The ethnic intimidation charge is a specific intent crime that has very specific elements to it. In order to be convicted of a violation of that statute, which is the record 750.147B, the person must do one of the following: cause physical contact with another person, damage, destroy, or deface any real or personal property of another person, or C, threaten by word or act to do an act described in subdivision A or B if there is reasonable cause to believe that an act described in subdivision A or B will occur. We believe that the prosecutor's case is lacking in one or more of those elements, because there's no evidence in this case that there was ever any physical contact. There's no evidence of any damage, destruction, or defacing of any real or personal property of the complainant in this case. We've heard testimony about some threatening words, and I will say for the record that the words that we're discussing in this case are vile and disgusting and reprehensible. But we have to be cautious, I think, because no matter how vile collectively we all believe that this language was, there are not only First Amendment implications, but there has to be a determination of whether there was reasonable cause to believe that there would be physical violence or damage to property in accordance with the third element. So the language that was used is language that ordinary people would find reprehensible, is the only word that I keep coming up with. I'm not going to stand here and defend that language. The question becomes whether it was A, protected by the First Amendment, or B, whether it is a threat that gives persons a reasonable cause to believe that there would be physical harm to either a person or property as a result. I realize this is a very fine line. I realize that in today's society, we ought not play around a lot with the kind of thing that we're trying to prohibit under this statute. However, in this case, what I think is apparent and what I think the officer in charge has admitted to is that Mr. Head was actually believing that he was communicating with another person. Not only did he believe he was communicating with another person, but he believed that that person was in Cameroon in Africa. He believed that this person was out of reach. His intent in doing so was not to cause physical harm or damage to one's property. His intent was to be annoying, to piss the guy off. He did believe that it was a male, as Detective Baker testified to. He had no understanding that there was any actual person associated with this account, that wasn't a scammer in Cameroon, Africa. The cases on this are a little bit all over the place, but I would cite the court to just a couple of the First Amendment cases that I believe are illustrative on these points. True threats, and I'm referencing now the case of People versus Osentowski at 274 Michigan 593. It's a 2007 case that was later modified by the Supreme Court, but as to sentencing issues and not as to these material issues. And at page, let's see, within page 602 in the Michigan Recorder. True threats encompass those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. And so the defense position is that it is, in fact, a threshold inquiry because it is an element of the offense. No matter how disgusting we find this task, we have to sort through these comments and determine whether any of these statements that were made by Mr. Head constitute true threats, constitute, as the statute says, one where there is reasonable cause to believe that an act described in subdivision A or B will occur. And A and B, of course, are the physical person damage and the physical property damage. The First Amendment argument comes in because as much as we would wish that it were not so, there are still protections for speech, even hate speech. When talking about the difference between hate speech and hate crimes, we have to acknowledge that there is a difference between the two. A hate crime has to involve an overt act that would demonstrate the intent to commit one of these hate crimes, and ethnic intimidation is certainly a hate crime. So the information that we developed at this examination reflects that Mr. Head misguided as he is, and using the language that he did, what was his true intent? Was it to cause physical harm to a person? And specifically, was it designed to cause harm to the complainant? It's easy to say, and it's easy to see how she would have felt hearing these words and seeing them all on her voicemail in this call log, which we haven't verified, and I don't know if all of those things actually came through to her and what account they went to, but I'm not addressing that today because this is probable cause hearing. It's not designed to test those facts. What I'm addressing is the intent that is required under the statute and what the evidence in this proceeding demonstrated as far as what that intent was. Was there an actual intent, and was there a reasonable cause to believe that one of those other acts would occur? Mr. Head is not charged with any other predicate offense, such as damage to any property belonging to her, damage to her person. And for that reason, we believe that none of these statements demonstrated an actual intent to be anything other than completely annoying misdirected as it was. It's clear that the transfer of intent cases are not going to provide me with a lot of recourse in this case, because many of them, usually involving a stray bullet, reflect that if you intend to harm one person and you miss and you in fact harm another person, that you're still just as guilty. I understand the transfer of intent. That's not my argument. My argument is whether or not this particular speech, as vile as it is, whether that satisfies the standard that we need to show under the ethnic intimidation statute. There is a much more recent case that actually has not made its way all the way through. It looks like it was an interlocutory appeal. It was the People versus DOCKET case, which is not even in any of the recorders yet. It was decided on June 24th of this year. The Westlaw site is 2021 Westlaw 2600819. And that case involved a kid with an AR-15. He posted a picture of his AR-15 on a website. I'm not sure whether it was Facebook or one of the other social media sites. And he talked about he was going to be bringing this bad boy up, referring to the AR-15, and then he was going to melt some snowflakes with the AR-15. When approached by the police, he admitted that he was referring to the AR-15 and he was referring to Democrats as being the snowflakes. The Court of Appeals, and it's just gone as far as the Court of Appeals so far. The Court of Appeals has determined that essentially it's a question of fact unless the speech could not possibly constitute a true threat. And where it could not possibly constitute a true threat, it therefore would become protected speech under the First Amendment. So as awful as we think some people are for posting every random thought that they have on some text or website, we have to be cautious, I believe, in making decisions as to whether those things constitute crimes. So for all of those reasons, we believe that this matter should not be bound over on the charge of ethnic intimidation in violation of 750.147B. As to the aggravated stalking, it's clear that what it requires is one or more credible threats against the victim, a member of the victim's family, or another individual living in the same household as the victim. So what we've established in this case, maybe, and your client will forgive me for saying this, but he was really dumb in and sending all these messages and thinking that he's another person, given not even that much credit, that it's, you know, inappropriate to send random messages when you don't know who the receiver is, the recipient. But in this case, what the prosecutor has not shown is that it was one or more credible threats against the victim. Even the officer in charge agrees that what Mr. Head told him was that he was communicating with a quote-unquote scammer, and he was surprised when he was told that this actually belonged to another person. He believed he was communicating with a male. Once again, I'm not defending the language. I can't imagine in 2021 in polite society that we're still talking about this, but some of this stuff is just completely inappropriate, doesn't constitute a crime, and particularly a felony under these circumstances. We assert that the answer is no, and that the felony charges should not be found over.
Thank you. Ms. Andery.
Can I just briefly, can I make it from here or can I get it open?
I need you to make it from the place that's gonna be most likely be picked up, and I think that's the podium.
Thank you. Your Honor, there's discussion in the argument by defense about this case where essentially the defendant's admitting to stalking, he's admitting to ethnic intimidation. He's just saying he did it to a different person than the person that testified last time, Ms. Robinson. And I don't think that that is a defense in this case, and if it is, then it would need to be up to a jury as the trier of fact. In terms of the credible threat that we're discussing, MCL 750.411I subsection 1 defines credible threat as means a threat to kill another individual or a threat to inflict physical injury upon another individual that is made in any manner or in any context that causes the individual hearing or receiving the threat to reasonably fear for his or her safety or the safety of another individual. Ms. Robinson testified, as well as Detective Yeager, about the extensive voicemails that were left by the defendant over a series of days. In those messages, the defendant threatens to rape Ms. Robinson, threatens to starve her and her children to death, threatens to kill her. In all of these threats, he uses terrible, racist, and ethnic intimidating words. Every single word that he's using, he's doing so to target the person based on their race or skin color. We played some of the calls last time. Detective Yeager said some of them today. The exhibits that Your Honor has actually has some of the transcriptions of the voicemails. And frankly, Detective Yeager testified to hearing all of the calls, over 200 voicemails, talking to the defendant, connecting that the voice is the same, as well as the fact that the defendant admitted that that was his voice, which is like, I believe, enough for identification. All of this other stuff about what type of investigation and pulling records and all of that, it doesn't matter. What matters here is that the defendant committed 2 or more willful, separate, non-continuous acts of unconsented contact with Nakia Robinson, that the contact would cause a reasonable individual to suffer emotional distress, that the contact caused the victim to suffer emotional distress, that the contact would cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, that the contact caused Ms. Robinson to feel all of those things, which she testified to, and then 6th being the credible threat, which I already went over. The same is essentially true for the ethnic intimidation count. All of it comes down to this, whether there's a credible threat, and ethnic intimidation statute does not require that we show that the defendant caused physical contact or damage any sort of property. It's that there was a threat by the defendant, by what he said or did to cause physical contact, threatened by what he said to cause physical contact or some sort of damage of property, and I believe that all of that is shown in the content of those voicemails. And in terms of what the defense that the defendant was attempting to get through by the prosecutor is essentially an issue without the entire fact.
Thank you. The court has listened to the witnesses in this case. On June 8th of 2021, I heard testimony from Ms. Nakia Robinson regarding the fact that she received all these threatening, vulgar, sexually vulgar, racist messages, and that she at some point in time did have a conversation with the individual who was making the calls, who she did not know at that time, and advised that person that to stop calling her. I have heard Mr. Head's defense to this situation based on the fact that there was, in his mind, is, as he stated, a scam that had occurred, and that he intended to harass the individual who was not potentially local, but in Cameroon. And during that time, he used whatever terminology he chose to use. The reality is that the prosecution has, in a probable cause conference, the burden of showing that a crime was committed and that Mr. Head committed it. With respect to the stalking charge, the prosecution must show that the defendant committed 2 or more willful, separate, and non-continuous acts of unconsented contact. In this case, that contact would have been with Ms. Nakia Robinson. They have clearly shown that, and they've clearly shown that the contact would cause a reasonable individual to suffer emotional distress. And Ms. Robinson testified that she did suffer the emotional distress. It would additionally cause any reasonable individual of color to feel terrorized, frightened, intimidated, threatened, harassed, and molested. And she has testified that it did cause her to feel this particular way. The argument has been with respect to whether or not it was credible threats. And from the defense, it seems to be that there was never any intent for it to be a credible threat, because he believed the person to be in another country and therefore not a credible threat. However, the messages, whether that part is true and it's up for a trier effect or not, the person who actually received those messages did perceive it to be a credible threat, and people in their household felt it to be a credible threat. So the prosecution has clearly met their burden of proof with respect to the stalking aggravated. With respect to the ethnic intimidation, the prosecution must show that there was specific intent to intimidate, harass Nakia Robinson because of her race and or color, threaten to cause physical contact with her, or that there was a reasonable cause to believe that these acts would occur. When one makes threats to hang someone from a tree or rape them or shit in their mouth, then the issue becomes a question of fact as to whether or not they intended it for that person or not, especially after that person is indicated to stop calling them. So that is a question for the jury and not for this court. The court finds that there is probable cause to find that these crimes were committed, and it is being bound over to circuit court. The telecommunication services malicious use, count 3, which is a misdemeanor, will also follow. Do you acknowledge receipt of the information, Ms. Mahoney, on behalf of your client?
Actually, I apologize. I don't believe I have a copy of the information, but I'm sure that I will get one from.
It is usually a part of the discovery packet.
It's the last page after the complaint, but I will get a signed copy of the information support as well. But it should be in your, it is part of your page, I think, 10 of the packet.
I'll acknowledge receipt based on my representation.
Thank you. Does your client waive formal reading, or do you want formal reading of the complaint?
No, Your Honor, we'll wait formal reading and stand mute.
Thank you. The complaint indicates that there is a charge of stalking aggravated, which is a felony carrying 5 years and/or $10,000, probation for any term of years not less than 5, ethnic intimidation, which is a felony carrying 2 years and/or $5,000, and telecommunication services malicious use 6 months and/or $1,000. The court will enter standing mute to counts 1 through 3. Pretrial will be
August 18th at 1:30 p.m.
August 18th, 2021 at 1:30 p.m. in front of Judge Archie Brown. Bond will continue.
Yeah, does the court know whether that will be Zoom or in person at this point? I know it's still on the list.
Yes, I wish I did know. I don't even know what, in my court, whether it's going to be Zoom or in person. At this point, you can plan on it being on Zoom. I'm certain that the court will let you know otherwise, and you should be in contact with the prosecutor because they are in that court often. They can probably tell you whether it has begun to occur in person or not.
Appreciate the court's consideration of the case and letting the subject matter.
Thank you. Sorry, what'd you say? Okay,
These are the ones that I sent out.
okay. Ms. Robinson, were you able to hear the next court date now?
Hello?
Yes, ma'am.
Hi. Yes, we were able to hear the next court date. Thank you. It's August 18th.
That's correct.
Or 1:30 or?
1:30, correct.
All right,
Thank
thank
you.
you.
State of Michigan versus Angela Marie Hayes, 20 F1 1359.
Good morning again, Your Honor. Ashley Londy for the people.
Good morning again.
Good morning again, Your Honor. Damian Woodson on behalf of Ms. Hayes. Your Honor, this is the date time set for the preliminary exam. I have looked in the gallery. Ms. Hayes still isn't there. She's not listed as a participant. I sent her a text message. She has not responded, and I have no explanation for her absence.
I do see one unidentified person of Ride 2. I'm not sure if that's her.
With the individual whose telecommunication device indicates ride 2, please state your first and last name. Ride 2. Ride 2 is the device. Would you please start your video and state your first and last name? Is there a Miss Angela Marie Hayes on this telephone call? The individual is not responding, Ms. Lundy, unfortunately.
Thank you, Your Honor. I will note for the record that on May the 18th, 2021, we were set for a preliminary examination. The defendant failed to appear at that time. She had appeared many times before, so I agreed to let this get set back for a PCC. And Judge Simpson did agree to do the same. On 6/3, she was present and then dropped off the call, so we adjourned to 6/17. And at that time, she did reject the offer and we got set for today's exam. I am at this time going to ask for a bench warrant. In the interest of full disclosure, I would not have been able to proceed if she did appear, but her pattern of non-appearance is very concerning to me and I'm not willing to waive her appearance today.
Thank you very much. Any response, Ms. Woodson?
Your Honor, I would ask that it be sent back for a PCC as opposed to a bench warrant, just because the people are also not ready to proceed today, and I can find out what's going on with Ms. Hayes. I know she was adamant about defending herself in this matter, so I do not understand why she's not here, but she's usually responsive to my text messages, Your Honor.
Have you talked to her in the last few days, Ms. Woodson?
I have not heard from her in the last few days.
Thank you. Have the other hearings, I take it they've been on Zoom, is that correct, Ms. Lundy?
That is correct, Your Honor.
Given that the people are not able to proceed, I'm going to give her one final opportunity and we'll give the people a final opportunity as well. So I'm going to set this over for another preliminary examination in front of me.
Thank you, Your Honor.
That's the next time I'm out here, Ms. Heather. I'll do the July 20th date. Preliminary examination is adjourned. And it will be held on July 20th, 2021. And that will be at 9 a.m.
Thank you, Your Honor.
And that will also be by Zoom, is that correct, Your Honor?
That will be by Zoom.
Thank you.
Thank you. Have a great day, everyone, and stay safe.
You too.
Thank you.
You know what, I've been checking the bond committee box. And there was something else. State of Michigan versus Daniel Gerard Webster, case number 18F20547.
Rob Dodd, on behalf of the people.
Good morning, Mr. Dowd.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Daniel,
Good morning,
Mr. Webster, I'm sorry.
Good morning, Mr. Gaddy. Good morning, Mr. Webster. Are you present?
I am present. How? Well,
Good morning, sir.
Your
All right.
Honor, today is set for a preliminary exam. The people are not ready to proceed.
Move to dismiss, Judge.
Thank you. Mr. Webster, I will grant your counsel's motion to dismiss this matter. The dismissal is without prejudice. And what that means is they are not able to proceed at this time, but if they were able to proceed at a later date, they could reauthorize this matter.
I understand.
All right, thank you. Case is dismissed.
Have a great
Thank you,
summer.
Your Honor.
Thank you. You too.
Your Honor, have a great week.
Thank you. You too. State of Michigan versus Gregory Eugene McNally, case number 1152, 1836.
Good
Hold on,
morning. Your Honor. Oh, I'm sorry. Good
hold on,
morning.
I'm sorry, Assistant Prosecutor on behalf of the people.
Good morning, Your Honor. Mark Hart appearing on behalf of Mr. McNally.
Good morning, everyone.
Good morning, Your Honor. Today is the time and date set for the exam. The people are unable to proceed at this time.
Defense moves to dismiss, Your Honor.
Thank you so much. Good morning, Mr. McNally.
Good morning.
At this time, your counsel's motion to dismiss this matter will be granted. Mr. McNally, I know you were on the call when I just said it to someone else, but it will be without prejudice, meaning that if at some point in time the prosecutor is able to proceed, they could reauthorize this matter. Do you understand that, sir?
Yes, I understand.
Thank you. Have a good day, sir.
Thank you, Your
Thank
Honor.
you. You as well.
Thank you, Your Honor. Stay safe, everybody. Take care.
Thank you. State of Michigan versus Cleo Ward, case number 19, FB 1861.
Andrew Childers appearing on behalf of the people, Your Honor.
Good morning, Mr. Childers.
Good morning, Judge.
Good morning, Your Honor. First Assistant Public Defender Quinn Anderson Legend on behalf of Mr. Ward.
Good morning, Mr. Ward. There he is. I have a receipt of it. Mr. Ward, today is the day and time scheduled for a preliminary examination in this matter. This means that the prosecutor would have to show by a probable cause standard that a crime was committed and that you committed it. At this point in time, are you in, it's my understanding that you wish to waive that preliminary examination and be bound over to circuit court? Is that correct, sir?
Oh, yeah.
All right. The court is in receipt of a preliminary examination waiver and sentencing judge waiver form. You've read this form and gone over it with your attorney and you fully understand it, sir? Do you understand what you've signed today, Mr. Ward?
Oh,
All right, this matter will be bound over to the circuit court. Do you acknowledge receipt of the information?
I do, Your Honor. Received the copy and I will just go and read and stand here at this time.
Thank you. I'm in receipt of the information as well. You will provide us with a signed copy of that, Mr. Childers?
Or I can sign the court's copy today, whatever.
All right, that you can sign the court's copy. The information has one count, count one of criminal sexual conduct, first degree. It's a felony, life or any term of years, and a mandatory minimum of 25 years and lifetime electronic monitoring. Do you understand that, sir?
Yeah.
All right. Pre-trial in this matter will be August 17th, 2021 at 1:30 p.m.
Thank you, Your Honor.
Does your client stand mute or are not guilty or plead not guilty?
Thank you at this time, Your Honor.
Thank you. Thank you. Do you need to approach Mr. Childers?
If I would, is the court signing the order for testing? To the company information?
Let's see if I have that. I do have that. I will sign it.
Thank you. May I approach?
Yes, you may. Do I give the order back to you or does it stay in the file? Do you know? Mr. Childers, do you get this order or do I give it back to I leave it in the file? Okay, thank you very much. Okay, I don't know. Can you sign it? All right, sir, you are all set. You need to be before Judge Carol Conkey on August 17th, 2021 at 1:30 p.m. Thank you.
Thank you, Your Honor.
Are we doing on this one?
It is no exam.
Okay. That's all you know, huh? People of the State of Michigan versus Maurice Van Patterson, 21 FB 1522.
Good morning, Your Honor. Marie Tanhus is a prosecuting attorney on behalf of the people.
Good morning, Ms. Tanha. Is there an attorney for Maurice Van Patterson Jr.?
I apologize, Your Honor. First Assistant Public Defender Kalina Anderson. With and on behalf of Mr. Patterson, we're ready to proceed.
No apologies needed. I understand you had to transition from one place to another. I did not know it was you. All right. Mr. Patterson, are you present?
He's muted, Your Honor.
Could you unmute? Oh, is he in the MTU hearing?
Yeah.
All right. You're still muted, sir.
You may have to get an officer to assist you, Mr. Patterson, if you're unable to unmute.
There you are. You got it, sir. You're unmuted now.
Oh, okay.
How are you this morning, Mr. Patterson?
I'm fine, Your Honor.
Thank you. Ms. Tanha?
Thank you, Your Honor. Your Honor, this is the date and time set for a examination. However, people are unable
I can hear you. Mr. Right, is that coming from MTU hearing? All right, Mr. Patterson, I think you're gonna need to remute yourself. We can't hear. There you go. Thank you. You're muted again. All right, I apologize, Ms. Tanha. Please proceed.
No problem. Your Honor, thank you. This is the date and time set for preliminary examination. However, people are unable to proceed at this point.
Move to dismiss.
Thank you. Mr. Patterson, I'm going to grant your counsel's motion to dismiss this matter. It is without prejudice, meaning that if the prosecutor is able to proceed at a later date and time, they could reauthorize this matter. Do you understand that, sir? You can nod up and down. I will let the record reflect he has nodded up and down, saying that he does understand it. Thank you so very much. Have a good day, everybody.
Thank you, Your Honor.
Thank you, Your Honor.
Are the attorneys on the Graham matter present? All right, they're ready on.
Sorry about that, Your Honor. I had trouble unmuting. I am present. I believe Ms. Tana is present.
Okay. Are you still waiting for your client, Mr. Gaddy?
Well, I don't know if ride 2 is Mr. Graham or not. I've called him. I was just on the phone.
Ride 2, are you Mr. Graham? The sir with the white shirt who's walking around in the room with who's not listening to me, but he's now touching his nose. He's not connected? Oh. Can you please put up okay. That individual is not connected to the Zoom, which is why he can't hear us talking to him.
Oh, he's not connected to audio?
Audio, correct.
Okay. Let me call him and see if I can find out.
I'm going to put up a message to ask him to connect. And you can try calling him as well. Heather, they need a breakout room. Yes, on the Curtis matter. Kalina Anderson and Mr. Curtis. Mr. Curtis, please hit the blue button when it comes, if you're able to, or get an officer to assist you so that you can join a breakout session with your attorney. Okay, he's gone. All right, they are ready on the Nakeem Ross matter. Mr. Danner, what will be happening on the Nakeem Ross matter?
Your Honor, my understanding is that it will be a exam.
I can hear, but I can't see, man.
That was also my understanding, Your Honor.
Thank you. Right to. Sir, could you please tell us what your first and last name is?
Derek Graham.
All right, Mr. Graham. State of Michigan versus Derek Graham, case number 21F20212.
Good morning, Your Honor. Marie Tan, Assistant Prosecuting Attorney on behalf of the people.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Graham, Your Honor.
Again, Mr. Gaddy.
Mr. Graham, state your name for the record, please.
Derek Graham.
Okay.
All right, today's the day and time scheduled for our preliminary examination in this matter.
Yes.
That is correct, Your Honor.
Yes, Your Honor. I believe we do have a resolution in this matter.
Thank you. What is the resolution, please?
Your Honor, Well, you made an offer previously to Mr. Graham through Mr. Gaddy that was rejected at the time. We've since been in communication. And my understanding is Mr. Graham's going to take advantage of the offer. The offer is to add account 4 of aggravated domestic violence. And with a successful plea to that, an agreement to full restitution on all counts. If there is any, we would dismiss counts 1 through 3. Mr. Gaddy, is that your understanding?
This is my understanding. I've gone over the plea agreement with Mr. Graham. In terms of restitution, there was an accident and I think they struck a pole, so it could be, so there could very well be some restitution that's not insignificant. So I'd ask the court to entertain a no contest plea in this matter since there was an accident and there would be civil liability potential. I have gone over the ins and outs of a no contest plea with Mr. Graham.
Is there a plea for?
Mr. Getty, was one filled out previously?
I do not believe so.
Then, Your Honor, I apologize. I would have to put one together and I can do so. Just be a few minutes.
Thank you. I will begin the process while you are putting together the form.
Thank you.
The aggravated domestic violence, what is the maximum on that charge, please?
Your Honor, it's a 1-year misdemeanor.
And I also, if it wasn't recited, I believe there was a sentencing agreement to no upfront jail time as well.
Is that correct? Ms.
Yes, Your
Tanner?
Honor. I'm sorry. Yes, Your Honor.
All right, Mr. Graham, did you hear the offer that has been placed on the record, sir?
Yes, ma'am.
All right. The offer is that if you were to plead to an aggravated domestic violence, which is a misdemeanor carrying a maximum of 1 year in the Washtenaw County Jail, and is that a $500 fine, Ms. Tanha?
I believe it's a $1,000 fine, Your Honor.
Right, and $1,000 fine plus court costs. They would dismiss the more serious counts, which is counts 1 through 3, assault with intent to do great bodily harm, assault with a dangerous weapon, and then the less serious one, which is also a misdemeanor, would be dismissed, the telecommunications device. Do you understand the offer that's being made to you here today, sir?
Yes, ma'am.
All right. For preliminary examination, is that what you wish to do? You wish to have those matters dismissed and enter a no contest plea to the added count 4 of aggravated domestic violence?
You said, yeah, but it's domestic, yeah, domestic, right, yeah. You said a 4th?
It's count 4. They're dismissing counts 1 through 3.
Yes.
Okay,
Sorry.
you're pleading to count 4. All right, please raise your right hand to be sworn.
I do.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God, sir?
Yes.
All right, thank you. I'm gonna go over some rights that you are gonna be giving up. Give me one moment. Do you understand that you have a right to a trial by jury and to have the assistance of an attorney, sir?
Yes.
You have a right to call witnesses to speak for you at trial. You can get an order signed by the court to require that they come to court. You have the right to see, hear, and question all witnesses against you at trial and to be a witness for yourself or to remain silent. If you chose not to testify, then the prosecutor could not comment on that. Do you understand that, sir?
Yes.
You have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand that right?
Yes.
You understand that by entering into a no contest plea today to the added count 4, that you will be giving up all those rights.
Yes.
With the exception of your attorney, you'll keep your attorney through the time of sentencing. If you're on probation or parole at this time, then you could be, it may result in the violation of your probation or your parole. You understand that, sir?
Yes.
In addition to that, there will be no automatic right to appeal this matter. Do you understand that?
Yes.
And are you a United States citizen, sir? Because if not, there could be immigration consequences.
Yes.
All right, thank you. To the charge of aggravated domestic violence, sir, how do you plead?
Guilty or no contest.
No contest? Do you
Sorry.
understand? That's okay. Do you understand what no contest means?
Like basically, I think I got, like, can you explain it?
Yes, it means that you're not going to say you did it. You're not going to say you didn't do it, but the court is going to treat you like you did do it. Do you understand that?
Like, far as like the domestic.
Yeah, the aggravated domestic violence. So you're not going to say you didn't do it. You're not going to say you did do it, but the court is going to treat you just like you did do it, and it's going to sentence you like you did do it.
Okay, yep. Mr. Getty did explain that to me, sir.
Okay, thank you. All right, now I'm going to review the report that has been sent to me, so give me one moment. I have case report number 21-0002239-001 with the date of issue of data report 2/26/2021 at the location of 333 First Avenue in Washtenaw County. On this date and time, that's weird. Is the officer's name Colford? Looks like the officer's name is Colford. Was dispatched to that location for threats. When he arrived, he actually witnessed at the Miss Desiree Johnson indicated that she was on Michigan Ave heading east towards Ypsilanti Police Department when she called. And he was westbound on Michigan Ave. He turned and observed a gold SUV and a black truck. And then he saw the truck speed up and ram into the rear of the SUV, causing the SUV to run off the road and strike a pole. Due to the force of the crash, both vehicles were immobilized. Ms. Johnson had called and said that at that time, Mr. Derek Graham was attempting to ram her. By the time the police got there, they watched him ram the vehicle in which she sat. And Graham indicated that he was attempting to speak with his girlfriend, think that council needs to establish I think it indicates that there's a girlfriend-boyfriend relationship based on the police report.
Your Honor, I'm sorry, could you repeat the report? There's two reports. Mr. Getty, which one?
I'm sorry, I thought this was a duplicate. I did send, I sent report 1 and 2.
I have the report that is the 001. I'm trying to see if I don't. Was it sent in a separate, was it sent in a separate email, Mr. Gaddy?
No, Your Honor, I have a.
Well, I'm sorry, Your Honor, and that one, under information, I think it's page 4 of 7. And I apologize if you already reviewed this part, but it says Desiree Johnson observed her ex-boyfriend following her in his truck. Under information, it starts with, I was dispatched to 333 First Avenue for threats prior to going en route.
Yes.
And it continues and it mentions that Ms. Johnson stated that her ex-boyfriend was following her in his truck and so on.
Right, and I also read that he said that he was trying to talk to his he believed current girlfriend, but yes, I did read that part. And then I read the part where the officer saw him ram the truck into the SUV, causing the SUV to run off the road and hit a pole.
Yes, and on page 6 of 7, it says Graham stated he was trying to speak with his girlfriend, Johnson.
I did read that part as well. So if you are satisfied that that is enough to establish the domestic relationship. Please.
The people are, Your Honor.
All right, thank you.
Thank you.
Yes.
You have a question, Mr. Graham?
No, I don't got no question.
The question that the court was trying to, part of the domestic violence statute is that you have to establish that there was a domestic relationship. And so I was trying to confirm the domestic relationship, girlfriend and boyfriend relationship is what I was establishing, sir. I find that there's a factual basis for the plea and that it has been knowingly and willingly made. Sentencing will be district.
Your Honor, I did send the plea form to Ms. Ball and Mr. Gaddy.
Thank you very much.
I am in receipt of it, Your Honor. I would note it doesn't include the sentencing agreement to no upfront jail time, but it has been noted on the record.
Yes, and Mr. Gaddy, you feel free to add that to your form for your file as
If you
well.
want to add that to yours, Mr. Gaddy, and then send it back over to us, we have to get it printed out up front anyway, so we can't print it back here.
Okay.
If you
I will
want
scan
to-
it and email it. I will print it, scan it, and email it, Your Honor.
Thank you so much. Sentencing will be August 23rd, 2021. At what time did you say? At 9:30 a.m. in front of Judge Tabby?
You said when?
Your sentencing will be August 23rd at 9:30.
In front of Judge Tabby, sir.
So you understand that Judge Washington is not going to be your sentencing judge. It'll be Judge Tabby. Do you understand that?
Yes.
That doesn't, and also, I don't know if it was, you're not on probation or parole, are you?
No.
Okay. So,
Yes, Mr. Gaddy?
Your Honor, Mr. Graham is just recently, in the last day or so, has had a death in the family. Would we address bond to Judge Tabby in terms of him going to the funeral when we know the arrangements, or with you?
You would address it with Judge Tabby once I have signed off today. You do.
Okay, thank you, Your Honor.
Is that involving out of state or something? Is that what the issue is?
No, but there are some prohibitions right now with the tether. So I as soon as I know the location of the funeral, I can address that with the judge.
Thank you so much. PSI is ordered in this case. In addition to that, could you please?
Oh, sorry.
MCL, Ms. Tanner.
Yes, Your Honor. The MCL for the added count is 7508182. And again, it's a 1-year misdemeanor and or $1,000 fine.
Thank you. All right. I believe we are all set. Bond will continue as is. For now, you can address any concerns with Judge Tabby.
Your Honor, can I say something?
Yes, Mr.
Can I say something?
Well, you have to ask your attorney whether you can say something or not, but I'll listen if he approves.
Can I say something to you, Mr. Getty? I really want to speak to him, honestly.
You want to speak to your attorney?
Mr. Getty?
Yes.
You want to break
about
up?
the bond conditions? What about the bond conditions?
Oh, Your Honor, right now, Mr. Graham is on a tether with rather strict bond conditions requiring him to basically stay home. We'd ask the court to at least extend those bond conditions to Jackson County and let him move freely in that county.
At least so I can see my kids. Okay.
So Mr. Graham is in Jackson County at this time. Is that what you're indicating, Mr. Gaddy?
Yes, that's where he resides, Your Honor. And the complaining witness in this matter is in Ipsy.
Thank you. Ms. Tanha?
I'm sorry, Your Honor. I thought we were done, so I didn't hear that full request. What was the request for?
The request is to lift the restrictions with respect to his tether to allow him to be able to go where he needs to go within Jackson County.
I'll leave that up to the court, Your Honor, as long as he stays out of Washington County where the victim resides.
Thank you. I will allow him to move freely throughout Jackson County. He cannot return to Washington County.
You understand that, Mr. Graham?
Yes, sir.
All right, you're all set then, okay?
Yeah.
All right, take care.
Thank you. So I understand we're having two exams, one on Zoom and one off Zoom. Is that correct? All right, thank you. I have three. Let's see. What do I have?
Your Honor, I don't know if it would, this is Mike Getty from the PD's office. I don't know if it would be possible for Your Honor and Mr. Danner and me to have a short breakout before the Ross matter.
thank you. I will do that. I have one more matter that I need to figure out what the status of it is before we. All right, thank you. I'm calling a quick matter first, and then I'll have the breakout room with you, Mr. Danner and Mr. Gaddy, okay?
Thank you, Your Honor.
Thank you. State of Michigan versus Cameron Gage Curtis, 21F20633.
Good morning, Your Honor. Marie Tanha, Assistant Prosecuting Attorney on behalf of the people.
First Assistant Public Defender Queen Anderson with it on behalf of Mr. Curtis. Mr. Curtis, please state your name for the judge, please.
I am present. Cameron Curtis.
Good morning, Mr. Curtis.
Good morning.
And Your Honor, we're still in plea negotiations as well as some additional investigation that I need to do on Mr. Curtis's case. I'd ask if Your Honor would reset this as a probable cause conference so that we can get that done and speak with Ms. Tanha. And at the appropriate time, I'd ask to address his bond.
Ms. Tanha?
Your Honor, in regards to the German, we have no objection, and then we'll address bond momentarily.
Do you have probable cause conference dates? All right. It'll take us a moment to get you a probable cause conference date because that's not something that is standardly given to the recorder when we start court.
Yes, ma'am.
Do you know how long you need for the probable cause conference?
If we can have 2 weeks, Your Honor, that should be fine.
Thank you. 2 weeks would be fine with the people, Your Honor. Thank you.
Thank you. It looks like we're on the 22nd, yeah. July. Yeah. We haven't heard back, but I can give you a July 22nd date, and if it's wrong, I guess they'll fix it.
Okay, that sounds good. Thank you, Your Honor.
July 22nd.
That works, thank you.
2021, and that will be at 9 a.m. I think they sent out a block to you to let you know exactly when it's going to be held. As for bond,
Yes, Your Honor. As to Mr. Curtis's bond, he's being held on another matter. I show this bond as a 5,000 PR bond, but he is held on a matter out of 14-2, at least until August 16th on a bond that he's unable to post. We would ask the court to set this as a $50 cash bond so that he's still getting some credit while he's in custody.
all right, thank you. Any response?
And Your Honor, based on our current office policy, as this was a request for a cash bond, I will stay out of that and leave it up to the court. Thank you.
I will do $5,000. You said 50?
Yes, Your Honor.
All right. So what I'm gonna do is 500, 10%.
Thank you. We'll be in touch, Mr. Curtis, okay?
Yes, ma'am.
All right. Thank you, Your Honor.
Thank you. I'm gonna go into a breakout session with the attorneys on the Ross matter. Sorry.
Just wanted to double check you are all set with me.
Yes, we're all set, Mr. Curtis. Oh. Okay. We have in the Bronson matter. Brosnan, just one witness in that one as well. Okay, thank you.
Deputy Phillips, you there?
I'm here.
All right, so you're here for the Ross matter. We had a breakout room with the judge, and the defense wants to file a motion in this case. And so the hearing would need to be adjourned for that motion. And so I basically wanted to see what your schedule was like, and if you have any kind of dates where you're planning on going on vacation or anything like that, so we can try to work around it, as I've been here for most of the morning.
I'm tentatively starting my FMLA late July, early August. Be on paternity leave for about 4 or so weeks.
About 4 to 6 weeks. So I'm assuming, so you're expecting, so your spouse is expecting, or a girlfriend expecting a child. You're going to be off around late July, early August, based on whenever the baby makes that call that they want to come. And then at that point, about 4 weeks out from there.
Yes, sir.
So that will put us in about September.
Sounds about right to me.
Right, Your Honor, I know that it will be a pretty short turnaround to try to get it to the end of July. I know July 27th will not work for the people at all. I have a murder exam that day, so I know I'm gonna be occupied the entire day for that one exam. So unless we could find something before the 27th, I think we would have to go out until September.
All right, thank you. We're not here on the 27th anyway. We could do the 20th. I don't know if Mr. Gaddy would be ready by then.
I think I could file a motion within that time. I'd certainly waive any period for Mr. Danner to respond, whatever that is, if Mr. Danner wanted to do that.
The other option, just so that parties are aware, will be September.
And Mr. Ross, can you put on your screen and unmute yourself, please?
Yes, I am present.
Thank you.
I'm not sure I never officially called the case. I haven't officially called the case anyway.
Oh.
And what was that September date, Your Honor?
September 14th or the 28th. So.
Mr. Ross, do you have a problem with moving this to September 14th so I can do a motion in this case?
Right now, I don't know if I'm gonna be scheduled for work that far. Is there any way we can do it before the end of July here?
Your Honor, I'm happy to do it on the 20th.
All right, let me call the case. State of Michigan versus Nakeem David Michael James Ross, case number 21 FB 1538.
Lou Danner for the people.
Mike Gaddy for Mr. Ross, Your Honor. Mr. Ross, state your name and turn on your screen.
Nakeem Ross.
Hello, Mr. Ross. It's very dark where you are. We can't actually see your face.
All right, 1 second.
While he turns on the light and becomes presentable, I will indicate for the record that we had a breakout session regarding this matter, at which time it was brought to my attention that the defense would like to have a motion heard regarding the stop in this case. I am giving an opportunity for the documents to be filed, and we will adjourn this matter for me to have those documents and responses if the people have enough time to get that done. It appears that based on an off-the-record conversation that was held on Zoom, that we're looking at the date of July 20th, 2021 for a return for the preliminary examination. Given that, I'm not certain that people will have an opportunity to file their response, but I am hopeful that we can get as much done as possible. Mr. Ross, do you understand what's happening here today, sir?
Yes, ma'am. It looks like we're just adjourning for now.
So that the motion can be filed on your behalf, sir. Do you understand that?
Okay.
So that will put the preliminary examination date on July 20th, 2021. And that is going to be at 9 a.m.
That's again via Zoom, Your Honor.
via Zoom.
Thank you, Your Honor.
And Your Honor, I just want to place on the record that as the court would have been aware of that, even though this is not necessarily the end of July, that babies have a habit of coming when they feel like it. So just in case there were to be that, I just want the court to be aware that there may be a chance that the people would ask for an adjournment if the birth of the child is earlier than anticipated.
That is correct. I did hear the officer indicate that he is going to be going on family medical leave according to the FMLA, and that it is contingent upon the arrival of his child. So the court has noted that, and we'll take that in consideration when we come back on July 20th if there's an issue. Bond is continued.
Thank you, Your Honor.
Mr. Gaddy, can you have that filed? How long do you need? Can you get it done in a week, or what? How long do you need?
Yeah, I will file a motion by the 13th, Your Honor.
All right. Thank you, July 13th, and that should give you some time to respond, Mr. Dennis.
Thank you, Your Honor.
Thank you, Judge.
That's the only matter I have today with this court, Your Honor. Thank you for your time.
Thank you, sir.
Have a good day, Your Honor.
Have a good day.
Congratulations, Deputy.
All right, Deputy, have a good one. I'll let you know what's going on.
Thanks. Have a good day.
Thank you. State of Michigan versus Dalton Alexander Brosnan, case number 20F2-1137. Thank you.
Good morning, Your Honor. Paul Stanley here on behalf of the Brosnan.
Thank you. Good morning, Mr. Brosnan. Good morning. Ms. Hughes, good morning, sir. How are you? Yes, you may.
For the record, John, right, no other witnesses in the courtroom. The only other witness that may be anticipating me into the courtroom is the detective, the officer.
Thank you. Just for the record, we're here for a preliminary examination today, and it's my understanding it's going to be an exam. You are calling your first witness, so that would confirm my understanding.
Your testimony to the court, swear or affirm to tell the truth, the whole truth, nothing but the truth. Please be seated.
Ma'am, I'm gonna need you to speak up, please. I couldn't hear what you said. Do you? Oh, wait, thank you so much.
I need you to state and spell your full name for the record.
You can use whatever you feel most comfortable with. Thank you.
May I call anything else? Can I call anything else? Yes. Same thing that you just did at any point, if I'm not hearing, please tell me to speak up and I will. Danielle, what is your last name? Dunbar. And in 2014, what was your last name? Buxton. Today, as you sit here, And for the record, Buxton for 2014 was BUXTON. And Danielle Buxton was your legal name back on December 23rd, 2014. Yes. Thank you. You recall the events of December 23rd, 2014. Yes. On that date, were you familiar with someone by the name of Dalton Brosnan? Yes. How did you know him? And prior to December 23rd, 2014, have you ever met him before?
I learned after the fact that we went to the taxes and I didn't know the taxes.
Fair to say you had no personal knowledge of him prior to December 23rd, 2014?
Correct.
If you were to see Mr. Brosnan again, would you recognize him? Yes. Is he present in the courtroom today? Yes. Can you please tell us where he is and what color he's wearing? There are two gentlemen behind you wearing blue suits. Okay, and what color hair does he have? Now, does he have a mask on his face? Yes. Even with the mask on his face, are you able to recognize him? Yes. Now, please put the record reflect the witness as identified.
Any objection?
For the purposes of the preliminary intimidation, hopefully I know that.
The record shall show so reflect.
On December 23rd, 2014, is that the date that you first met the defendant? Yes. Where did you meet the defendant?
Anthony Belo's house and Hamilton Road at a house gathering.
And the court, is the court picking her up? Or do I need to ask her to speak up?
She needs to speak up a little bit more.
Can you raise your voice a little bit as you answer questions?
The house that we were at was 215 Hamilton Road, I believe. Was Anthony Belo's house.
Do you know how to spell Anthony's last name?
I think BELLORE.
Thank you. What was going on at Anthony's house?
We had just got back from a basketball game, from the basketball game, and he had some friends over, and we were hanging out with them. They were playing beer pong.
Now, when you use the word we, who are you describing?
Me and my best friend, Michaela Mandel, and her boyfriend at the time, Anthony Below.
Can you spell Michaela's last name?
MENDEL.
Thank you. While at Anthony's house, were there other people there that were hanging out together with you and Michaela?
I know there was a girl named Angel, and her boyfriend at the time, I think his name was Chad. And then there was a couple other people that I'm not familiar with.
What about the defendant? Was he there?
Yes.
Was he there when you first arrived, or did he arrive at a later point?
I think he got there later because nobody was really at the house before Anthony and us back.
Could you please tell the court about your first interaction with the defendant?
What was that?
Could you please tell the court about your first interaction with the defendant?
I remember being introduced in the basement, and he offered me a beer, and he was just trying to talk to me, but I wasn't interested. And I remember I told him I was texting someone else, just talking to somebody, just trying to distract myself.
When you say that he was trying to talk to you, but you weren't interested, what was he trying to talk to you about?
Like he flirted with me.
And is that what caused you to then tell him you were talking to somebody else?
Yes.
Now, when you say you were talking to somebody else, are you referring to some type of romantic relationship?
That's what I was referring to, but I wasn't actually talking to anyone.
Just using this as some type of decoy to deflect that attention.
Right.
When he offered you the beer, did you say that?
Yes.
Were you consuming alcohol that night?
Yes.
Do you recall how much alcohol you had to consume that night?
A beer or two.
At any point, did you see the defendant consuming alcohol?
Yes.
Do you recall how much alcohol you saw him consume?
Several beers, I believe.
I can hear you.
Several beers.
That yes. Do you recall what type of beer it was that you were consuming?
I don't know.
What about the type of beer that he was consuming?
It would have been the same time, but I don't know.
Okay. So once the two of you were talking in the basement and offered you the beer, did you have continued interactions with him at Anthony's?
I just kind of turned away and started talking to my friend again.
And for me, to make sure that I'm making a clear record, the beer that he offered you, did you drink it? Yes. When he offered you, when he handed it to you, do you know whether or not it was open or closed? It was open. Okay, what happened next?
I don't remember everyone else leaving the basement, but I remember being alone in the basement with phone. And then all of a sudden I remember kind of going upstairs, but like people weren't there, people were missing. And I was looking for my friends. And then the next thing I remember is waking up on a mat.
I have to take a step back because I didn't hear you. You said alone in the basement with Dalton, the defendant. Is that a yes?
Yes.
You said you came upstairs and people were missing. What does that mean?
I couldn't find my friend at table.
And then what happened?
I just remember feeling disoriented, and I remember waking up on the mattress in a different house.
Can you tell us more about the feeling of disorientation? What were you feeling? What sensations were happening?
I got confused and like dizzy.
Do you have any memories about your vision?
No.
Okay, so the next thing you remember is waking up on a mattress. Is that you're not in your head? Can you please tell me what happened?
I remember something on my back, and he was trying to take the jeans off, and they were kind of tight, so they couldn't come all the way off, and they were stuck around my ankles. And I remember crying and telling him to stop, and he didn't stop. And he kept trying to like push my hands away, and he pinned my knees against my chest and held me there. And proceeded to rape me.
Can I interrupt and ask a couple of questions to get further detail on some of this? So yeah, the reason I keep asking that is because we're being recorded, so we have to think about it. When you say he was on top of me, are you referring to the defendant?
Yes.
You testified that you were crying and you were telling him to stop. You're realizing that.
Yes.
While you were doing that, were you doing anything with your arms or legs?
I remember feeling that my body felt really heavy, like that it was hard to move. But I remember trying to push his hands away and trying to push him away. I couldn't really move my legs because he was holding them.
I want to make sure I got the best understanding of this. I believe you indicated that you woke up with you on your back.
Yeah.
When you say
On my legs, pushing on my knees, pushing my knees into my legs.
would it be an accurate description to say that you are curled up in a ball on your back?
Yes.
And your knees are towards your shoulders or your chest?
Yes.
And then on your legs, your hands are where?
Just over my knees.
On the shin area? Okay. Yeah. Did you say that, you testified earlier that he was trying to pull your pants down?
Yes.
Could you please describe that a little bit?
What was that?
Could you please describe that?
Well, I remember I was wearing skinny jeans and like the bottoms of them are tight, so it's hard to get off of your heels. And you couldn't get them off because you left them like half on. And eventually.
Now, I have to apologize during my job. Sometimes I have to ask you stupid questions, but I apologize. Were you wearing underwear?
Yes.
Was he pulling the underwear down as well?
Yes.
While we were crying and telling him to stop, and trying to push his hands away, what was he doing?
Staring off blankly into the distance, never looked at me.
Did he ever respond to you verbally?
No.
Now, physically, what was his body doing?
Holding me down. I just remember him like standing over me and then kneeling over me.
This is on the mattress as well.
Yes.
before I interrupted you and went back and asked specific questions, your testimony ended without you saying, recall saying that. Could you please describe what does that mean?
He put his finger in my gun.
When he did this, was this during the time that you were talking to yourself? Yes. Do you know whether or not you were very what happened from when he is pushing, holding on to your shin area, pushing down your your knees, and when he began to kind of use the directly like Thank you for asking to clarify. I'll ask a more specific question. Once he first penetrated through the penis, how long did this happen?
I don't have like an exact time. I would say at least like 5 to 10 minutes. And I just felt like I stopped trying to fight back at some point and just lay there and kept crying.
When you say you stopped trying to fight back at some point, before that point occurred, what were you doing?
Just telling me to stop, continually trying to push him off of me. But my body just wasn't, I felt like I just couldn't keep pushing him off. It wasn't working.
Now, as you're sitting here today telling us about this, would it be fair to say your demeanor is pretty calm? Okay, yeah. Now, what was your demeanor like during
Terrified. I mean, I was throwing a ball. Not that I really had a choice, but it was really just scary. I felt really big.
What happened now?
Eventually we finished or whatever and rolled over and just passed out. And I laid there until I put it up. And then I got up and I left the room. I'm pretty sure I put my pants on inside out. And I just went downstairs and found other people down there.
Step back and ask you when you say you finished or whatever. That are you referring to when the penetration stopped?
Yes.
Then you said you laid there until you could get up. What does that mean?
My body felt paralyzed. So once I kind of realized what happened and that it was over, I felt like it was dead.
Where was the defendant when you got up in Darkville? And once you were able to get dressed, what happened?
I saw blood on the mattress and that kind of scared me. But I went downstairs and one of his roommates was down there. He gave me a cup of water, let me use his phone, asked me if I was okay. But this wasn't the first time that it happened.
When you say that you saw blood on the mattress, was that, let me make sure I'm asking the right question. Where was the blood on the mattress in comparison to your body? So it was where your body was.
Yeah.
Okay, I apologize. So you said you were downstairs, there was a conversation with was that his roommate or somebody else?
I think it was his roommate, Ryan.
Then was there a point that you, and I should take a step back. This place that, when you go downstairs, let me take another step back. This place we're in this home where the mattress is, where in the home was this room with the mattress?
The attic.
And when we're talking about an attic, I'm now picturing you're in a house. Is that fair to say? When you went downstairs from the attic, is this the same place that Anthony's house, or is this a different place? This is not the area, I'm gonna refer to the party as a factor, this was not.
Small gathering.
Okay, yes,
yeah.
So when you come downstairs and you interact with the defendant's roommate, that's what you're correcting on? Yeah. Is this the first point that you realize that you're no longer at Anthony's house, or did you already realize?
I didn't remember ever like leaving something about getting to the house.
Do you know where this house that you're at, would be at? Do you know where that's located?
The Delta House out the tractor house.
Do you know the address?
123 College Place, I think.
Is it fair to say that that's the facility that you want? Yes. Thank you. Now, once you're at this 123 College Place, and you were downstairs in the living room area or somewhere else?
There's like a living room area in the kitchen.
Were you able to make, well, what did you do after you had the conversation with the defendant?
He let me borrow his phone and I was trying to call Nikki so I could send it to him. So I could get out of there because I didn't know where I was and why I was there and didn't want to be there anymore.
Now, did you have your own phone at the time?
I did, but it was like missing at some point right now.
Were you able to make contact with Michaela?
No.
Was there a point that either you left this address or somebody came up to pick you up? How were you able to exit this address?
The roommate got me a bed to sleep in that night. Not Dalton's bed, and I went to sleep. And when I woke up, Anthony and Michaela were there waking me up, telling me to go home.
Okay, so to make sure I have the timing properly, when you leave this attic that's upstairs and you come downstairs to the living room area, is it the next morning or are we still in the night before?
It was still nighttime. It must have been midnight or maybe later.
Okay, so sorry for interrupting. So you said they found you, the roommate found you a bedroom to sleep in? Is that again? The roommate found you a bedroom to sleep in?
Yes, he found me a different bed.
And did you go to sleep?
Yes.
And then what happened?
Then Michaela and Anthony woke me up.
And are they the ones that you left with?
What was that?
Are they the people that you left that address with?
I was with Nikki and Michaela. Anthony stayed there because he lived in the house.
Okay.
But they did help me find my shoes, which was still at Anthony's house.
Did you and Michaela leave this 123 college and go to Anthony's house with your shoes?
Yes.
Did you wear any, when you left the college address, did you wear shoes outside or did you have anything on your feet?
Leaving Anthony's house, I had socks on, and I guess I walked through the snow.
Oh, sorry, I apologize for it. My question is when you're leaving the next morning.
Oh, no, I didn't have any shoes.
Ryan, may I have a moment?
Yes, you may.
Thank you, I have no further questions.
Thank you. Your witness?
Thank you, Your Honor. If I refer to you as Austin, Dunbar. Ms. Dunbar, one of the questions that the prosecutor was asking about how much you had to drink that night. Remember those questions? And you said at some point that you don't remember the party on Hamilton, right? And so there's a gap in your memory between being at Hamilton and then being at the house of Dalton. Right, okay? But you do remember some details about what happened, right? Okay. Remember, obviously, that you drove to Eastern, did you drive with Mickey?
She was at, yeah.
Okay, so the two of you drove from your parents' home or from your hometown to Eastern, right?
Yes.
Okay. And you went to the basketball game, right? Remember that? You remember then going from the basketball game, going to this get together, right?
Yeah.
Okay, and you remember at the get together that, well, you told us what the address was, right?
Yes.
Okay. And you remember there were about 9 or 10 people there, right?
Mm-hmm.
Okay, is that a yes?
Yes.
All right. And you testified a moment ago, you remember drinking 1 or 2 beers, right? Okay. And you remember at some point that you were alone in the basement of Dalton, right? All right. And one of the other things that you didn't tell the prosecutor about a minute ago was the fact that at this party, you were pretending to drink vodka. Is that right?
Some liquor was there, I didn't remember that yet.
You don't remember?
I didn't consume it, no.
Sorry?
I did not consume it. No.
Right, you were pretending to drink.
Yeah.
You don't remember what you were pretending to drink?
Right.
You remember telling somebody that you were pretending to drink tequila?
I don't remember the specific alcohol.
Okay. You remember being in the basement, right?
Yeah.
You remember talking to Dalton about the fact that the two of you went to the same high school, right?
Yeah.
You remember talking, or the fact that you yourself did not play beer pong, but other people were, right? Okay. And you remember specifically that there was, other than Nikki, there was one other girl there, right?
Yeah.
You remember her name, right?
Yeah.
You remember her name being Angel, right? Yeah. You remember her boyfriend's name being Chance, right? Yeah. Now, you said something about the fact that at some point you became confused or disoriented, right?
Yeah.
All right, and now, today is not the first time that you've talked to anybody about what happened, isn't that correct? Okay. In fact, after this incident, you had text message conversations with your friend Nikki about this night, right? Okay. And you also, I believe on December 25th, went to the University of Michigan Hospital, is that right?
Yeah.
And that's because you said something to your mom, and your mom wanted you to go there for the exam, is that right?
Yeah.
Okay. Your mom took you there?
Yeah.
And you got to the hospital, and they asked you what happened, right? Okay. Is that a yes? And they're there to get this examination done, right? Yeah. And you want to be completely honest with them about what happened, right?
Right.
Right. And they're going to treat you if you need to be treated, right? Right. And you told the, I'm sorry, you didn't tell anybody at the hospital about the fact that you were disoriented or you were confused, right?
I don't recall if I did or not.
And in a hospital, they can draw your blood, right?
Right.
They can do tests on your blood to see if there was anything in your system, right?
Right.
Nobody ever did that, did they?
No.
So, back to December 23rd, 2014, you went to this party on Hamilton, right? Yes?
Yes.
You went there with your friend Michaela, right?
Yes.
And her boyfriend?
Yes.
Okay. Who else was at the basketball game?
I think it was just the three of us.
Okay. You left the party with Mr. Brosnan, is that right?
From what I know.
Okay. And just so we understand, you were in control of the point where you, in being examined, no one at University of Michigan Hospital found any abrasions on your elbows or knees, did they?
No.
Okay. You were able to walk from wherever you were to Mr. Brosnan's car, right? Without falling. You didn't, okay. You don't remember what you're saying?
I don't know how.
But you didn't have any injuries on you, any skin, knees, or elbows, right?
No, I had bruising on my thighs.
And then you rode in his car with him to the house, as far as you know, right? In fact, your phone was eventually found inside his car, is that right? Okay, you got into the front seat of his car without falling down, right?
I don't recall being in the car.
When you got to the house after the party, you went from the party to house where Mr. Brosnan lived, and you went upstairs apparently, right?
I don't remember going upstairs, but, yeah.
How many floors are there in this house?
I just remember the staircase up to the attic.
Okay, what do you remember about it?
And it was kind of a narrow staircase, like how you can imagine an attic staircase would be a smaller staircase than a normal.
Okay, and when you you don't know how many floors there are in this house?
I can recall.
If I understand correctly, you had said something a moment ago on direct examination that you were curled up in a ball while you were on this mattress at some point?
Yes.
Okay. If I understand correctly, you said you brought your knees up to your chest?
I didn't really, but that's where they were.
Okay. And did you ever tell the police in any interview that you would hold your knees up to your chest to try to stop him from getting sex with you? And so you're saying you never said that to any police investigator?
I don't believe so.
Okay. Now, when, so if I understand correctly, you said that your pants were not completely off, but were down at your ankles or your shins?
Yes.
And that's why while you have your knees up on your chest, your pants are still on?
Yes.
Okay, and you're saying that's when the intercourse occurred?
Yes.
Okay. Now, the first time that well, first of all, you had a conversation with Nikki the following day, the two of you drove home together, is that right?
Yes.
Okay. And she was driving?
Yes.
All right. And how long does it take you to get from Ypsilanti to your home?
About 30, 40 minutes.
Okay. And it's just the two of you in the car?
Yes.
You also had text messages with Nikki, right? Okay, so you told the court a moment ago that you only drank 1 or 2 beers. Is that right?
Yes.
Okay. The text messages that you had with Nikki, you actually saved some of those and gave those to the police. Is that right?
Yes.
All right. Did you do that using a screenshot?
Yes.
Okay. Can I ask you, at the time, did you have an iPhone?
Yes, I think so.
Okay, and do you have a cloud account with Apple?
I'm not sure if I did at the time.
So you took these screenshots and you took those, right? Was it the detective?
I think the detective might have downloaded them from my phone when I went.
Sorry, did you say downloaded from your phone?
Yeah, I think they took them from my phone.
How did they download them from your phone?
I'm really not sure. I think maybe they screenshot them. I'm really not sure how that works.
Okay. In those text messages with Mickey, your friend, you were talking about what had happened the night before, right? Or actually 2 nights before, something like that, right?
Yes.
Okay. And you told her in one of the text messages that you said, quote, "I don't think I want to drink for a while," also known as ever again. Did you say that to Nikki in the text message?
Yes.
Okay. Now, in talking to Nikki about what happened, you never mentioned anything to her about the fact that you were disoriented or confused in any of these text messages, did you?
Correct.
And Mickey told you that you had actually told her you were leaving with Dalton, you were going to hook up with Dalton, and that you had left her there at the house. Not offered to prove the truth of the matter, sir, just that the statement was made.
For what purpose are you offering it, sir?
Because it's a statement of offering it for the purpose of the effect on the listener, and that she's the listener, text message comes in and says, what I just said. Her reaction to that is important. So the statement has to be not offering it to prove the fact that she was hooking up with, well, the statement is, you told me you were going to hook up with adult, then you left. Okay, not offering it to prove the truth of that matter asserted, just as she said it.
That who said it, first of all?
Who said it is the witness said.
Okay.
No, I mean, her friend is saying, you told me this, you told me X.
So you're offering it to get to her reaction of that?
Right, because, yes. I mean,
Then you can ask her if the person sent that to you.
okay. But I'll rephrase it.
Okay.
You remember during those text messages that Mickey said to you, that you told her you were going to hook up with them, and then you left her at the house.
Objection again, hearsay. The counsel has only addressed my hearsay objection when it comes to one of the two statements. We have double hearsay here. He's saying this is effect on the listener when it comes to her. That would cure, if that was an appropriate argument, that would cure only the receiving the text message. Now, my objection is to hearsay to her allegedly saying that the day before. He has to also cure that hearsay, has not addressed that, because the text message is being admitted for matter of fact. You said this. That is assertion for the truth of the matter asserted. You said this.
All right. I'm not receiving it for the truth of the matter asserted. I'm only receiving it to see if that was in fact received and whether or not she had a reaction to it. That is it.
Thank you. When Nikki texted you that you had told them, well, first of all, do you remember receiving that text that said where Nikki had said you told her you were hooking up with them and then you had left her there?
Yes, I remember that.
Okay. And this was a text message that was either 1 or 2 days after. Do you know when it was?
Yes.
When?
What was that?
When was the text exchange between you and Mickey?
Either Christmas Eve or Christmas Day of 2015.
Okay. Was it Christmas Day that you went to U of M hospital?
Yes.
And you're saying that maybe the day that you had this text conversation with Mickey?
I believe so.
Okay. And your response to Mickey was not that didn't happen. You just stopped talking to her at that point.
Yes.
The first time that you ever contacted anybody and contacted the police about this incident was not until January 18, 2015. Isn't that right?
Yes.
About 3 weeks after this incident occurred, right?
Yes.
And you said that you had conversations. I'm sorry. I'm saying you had said before that you drank 1 or 2 beers. That's what you say. That's all you drank, right?
Yes.
And you agree with me that there are parts of this night that you don't remember, right? And you would agree with me also that drinking alcohol affects your memory, doesn't it? Okay. And when you drink alcohol, sometimes you have trouble remembering exactly what you did, right? Okay. And you have trouble remembering what you said, right?
Right.
You have trouble remembering how you acted.
Right.
Yeah. And you have trouble remembering details of the night, right? Okay. So when, and then remembering, not just remember what you said or how you acted, but at some point, or other parts you can't remember, some parts you can remember, right?
I'm going to address this as well and ask for clarification. My objection is relevant at this point. I wasn't objecting initially, but my relevance objection is based on the testimony of this room that 1 or 2 years. My clarification request is I'm understanding the defense counsel is asking these questions generally and not in regard to this individual night, which then we have tonight.
Thank you. Response?
I think her understanding about what alcohol may or may not do to her in consuming it is relevant. Of course, determination about the credibility is obviously always an issue.
With respect to the objection as to relevance, I think she has testified generally about what alcohol does. I don't think that that's relevant to that particular night. It may be relevant if you ask her more specifically what her reaction is to alcohol. She has also testified that she only had 1 to 2 beers. And so with respect to that, Ms. Hughes, you can further qualify that upon redirect as to whether or not it had any effect on her that night, but I think he gets to ask the question.
Thank you.
Thank you. Then along those same lines, you say that there are parts of this night that you can't remember, right? You don't remember everyone that you talked to, right? You don't remember everything that you said, right? You don't remember everything that you did, right? Have you talked to or spoken to Angel?
Yeah.
The woman since that night?
Yeah.
Okay, how many times?
Maybe twice, maybe 3 times.
And are these telephone conversations, face-to-face conversations, or text messages?
Telephone.
I'm sorry?
Telephone.
You spoke to her on the telephone?
Yeah.
2 or 3 times.
Is that a yes, ma'am?
Since, when was the last time you spoke to her?
Maybe 2 months ago.
And how did that come up?
There's a lawsuit against you and you, and we're both the record of that lawsuit.
And you think we were both what?
We're both in the lawsuit.
Okay. So in regard to, so you are a plaintiff in a lawsuit that is suing the university because of this particular incident, right? Now, in that lawsuit, you're asking that the university pay you in excess of $75,000, right?
I don't know what amount.
Did you see the complaint?
I haven't seen any amounts listed, no.
I just asked you if you see the complaint.
I saw the lawsuit that I'm listed under.
You're listed as, you're listed as Angel as well, right?
Yeah.
And you recall that the lawsuit asks that the defendants pay you in excess of $75,000. Remember that?
Again, I don't remember the amount, but I remember the lawsuit.
And you're represented by a lawyer in that lawsuit?
Yes.
He's here today, right? It's true, isn't it, ma'am, that on the night in question, when you were at the party, it was down in the basement where the beer pong was going on, right?
Yeah.
Okay. And at some point, you and Mr. Brosnan were there alone.
Yeah.
Okay. And when you were alone, you and he were kissing, isn't that true?
No.
Fact is that you and he were kissing when you were in the basement when other people were around, isn't that right?
No.
Did you talk to Angel about that?
Yeah.
If I understand correctly, then, so we talked about the fact that the first time you contacted the police. Contact we had with the police was in March of 2015. I'm sorry, February 14th, 2015. And that's a face-to-face, you guys, a different detective that was in the police department?
I believe it was a different.
Okay. And when you went, I'm sorry, to bring it back up, January 18th, who did you go to the police station with? Did not go to the hospital, did not go to the police station, January 18th, right? Okay. When you were interviewed on February 14th, your mom drove you there, I'm sorry, she drove you both times, did I already ask that? Okay. So your mom drove you there on February 14th as well?
Yeah.
All right. And when you were interviewed by the detective, was your mom present during the interview? Was your mom present during the interview the first time you were there? When the detective asked you on February 14th, 2015 about what happened, you knew that he was taking notes about your conversation, right? Okay. And wanted to be accurate with him, right? You didn't want to lie to the detective, right? And a moment ago, you said that you were, in the words of the prosecutor, curled up in a ball with your knees up on your chest, right? And that was when you say that Mr. Brosnan was trying to take your pants off, right? That's correct. Did you say yes?
Yeah.
Okay. You remember telling the detective on February 14th that when Mr. Brosnan was trying to take your pants off of you, that he was on top of you and straddling your legs. Remember saying that?
No.
And you remember telling him that when you first had any memory, is that when Mr. Brosnan was on top of you and between your legs. Remember that?
Yes.
I can have 1 second.
Yes, you may.
Thank you. I have nothing further on. Thank you.
Thank you. Ms. Hughes? Thank you. Is there a motion? Thank you, ma'am. Thank you. Anything from the defense?
Judge, the defense has no witnesses to defense rest.
Thank you. All right, is there a motion?
Thank you, Honor. At this time, people move to provide over the written the victim testified to the defendant. penetrated her vagina with his penis and that he did so while using force. He specifically testified that the physical force was the use of his hands on her legs, pushing her down while she cried and repeatedly asked him to stop. At this point, now we're just asking the court to find over as
Thank you very much.
Your
Mr.
Honor,
Stabler?
in regard to this, understanding the factual discrepancies between the victim's testimony here today and what she was told police in the past, I believe that these creates questions of fact. And that's all I have to say.
Thank you very much. This is one count of criminal sexual conduct in the third degree using force and or coercion. Given that the complaining witness in this particular case has testified that she did not consent and found herself in another house after being disoriented and cannot figure out how she got there, and that at that time, there was a point in time at which, in that particular room, there was a point in time at which at 123 College Place, Mr. Dalton Alexander Brosnan did hold her legs down in a fashion that had her knees to her chest, and she was unable to move due to feeling as though her body was extremely heavy and outside of her control, and that she was physically held in that space using the force of his hands against her shin area, that there was force used to penetrate her vaginal area. I do find that there's probable cause to bind this matter over and that a question of fact has been created. The matter is bound over to the circuit court.
Thank you, Your Honor.
Do you acknowledge receipt of the information?
I'll now receive the journal information there, the formal reading.
Thank you. The court will enter a not guilty plea by the standing of mute to count one. Do you plan to sign the court's copy of that document today, or do you have a copy to provide? Thank you. Thank you very much. I do acknowledge receipt of the signed copy, which indicates one count of criminal sexual conduct in the third degree is a 15-year maximum with a mandatory testing and DNA to be taken. This matter will be bound over for a pretrial on August 17th, 2021 at 1:30 before Judge Punky.
I'm sorry, can I have that again?
August 17th,
August
2021 at 1:30 before Judge Carol Punky. If there is nothing further, bond will continue in this matter.
Thank you, Judge.
Thank you. A copy of the what? I'm sorry. Yes. Find that. don't know which boxes I'm supposed to check on this form. Heather, I don't know. I know you don't know. Like there's a whole bunch of boxes. And I don't know. Do I just decide or is there a standard protocol? Maybe I need to talk to them about that. I didn't do that last time when we had these places here and that kind of thing. So we'll have them check it out, Brian, and then I'll find out whether or not there are boxes that I need to check on that testing form, please. Okay. And then we need to find out if Judge Freshour needs assistance.
Yeah, let me run this one.
Okay, thank you. I'm sorry, what? Oh, really? Okay. Okay. Well, the problem with this one is that this is not the one that, this is the old one. There should be a new one coming over. The defense attorney was going to sign. There should be another email that he was sending to you. Okay, do you not see it?
No, he has not sent me an
Okay,
email. Let me follow up.
that's what he told me he was gonna do on the Zoom here. A separate email.
Correct, yeah, thank you so much.
That is my understanding. They'll give it to you out front. You have to check out at the counter. Thank you. You too. While he does that, Heather, I'm gonna go to the restroom and see if there's any short matters they have that we need to do. If there's not, do you want to go to lunch?
No, maybe not, seeing how long for me about what they have going on over there.
If we can be.
Yeah, because
Oh, wait, let me make sure I'm not. It might be still working.
Sorry, Your Honor.
No worries.
Do you guys need to log into the new, for the new cases, or can they hear me?
You will have to speak up. They do have a difficult time hearing, is what I've been told. So we all have to speak very loudly for them to be able to hear us. Ms. Sloan, are you able to hear us, ma'am?
Yes.
All right, could you show your screen, please?
Yeah, I'm hoping it works because my camera's not. I don't know if I'm doing this right.
You just need to push the video button and it should show your screen. There's a mute button and a video. There's a mute microphone button and a video camera. Those are the two. One allows you to talk and the video camera allows me to see you. Or
So I do have it on, so it's my phone.
Okay.
And I just checked. Sorry, it's definitely my phone.
All right, thank you. Court will call the case of the state of Michigan versus Jessica Ann Sloan, case number 20 FB 1914.
Good morning, Your Honor. Marie Canhas is the prosecuting attorney on behalf of the people.
And good afternoon, Your Honor. Stan Bernstein. I hear for Ms. Sloan. I'm in the courtroom. She's by Zoom.
Thank you. Hello, Ms. Sloan. Please state your name for the record.
Hi, Jessica Sloan.
Thank you, Ms. Sloan.
Your Honor, this is the date and time set for a preliminary examination. However, people are unable to proceed at this point.
Your Honor, we move to dismiss. We understand that any dismissal would be without prejudice.
Thank you. Ms. Sloan, as your attorney just said, I am granting this motion to dismiss. The dismissal is without prejudice. And what that means is if at some point in time the prosecutor is able to proceed, then they could reauthorize this matter. Do you understand that, ma'am?
I do, Your Honor.
All right. This case is now dismissed. Thank you.
Thank you.
You're all set, ma'am. Have a good day.
Thank you. You too.
Thank you. Are you handling the Odom matter?
Yes, Your Honor.
All right. I'm sorry? Yeah, I know. State of Michigan versus Sean Martel Odom, case number 21 F20631.
Good afternoon, Your Honor. Marie Canhas, assistant prosecuting attorney on behalf of the people.
Good afternoon, Erica Julian appearing on behalf of Sean Odom. Sean, will you identify yourself for Judge Washington?
Sean Martel Odom.
Good afternoon, Ms. Julian. Good afternoon, Mr. Odom.
Good afternoon.
Today's the day and time scheduled for a preliminary examination in this matter. I'm substituting in for Judge Anna Freshour.
Your Honor, the defense is ready to proceed.
Your Honor, this is the date and time set for a preliminary examination. However, people are unable to proceed at this point.
Is there a motion, Ms. Julian?
Yes, Your Honor, I believe that I understood what Ms. Hannah said. I will make a motion to dismiss.
She said that she was unable to proceed. And so based on the attorney's, your counsel's motion to dismiss Mr. Odom, this matter will be dismissed. It is without prejudice, meaning that if at some point in time the prosecutor is able to proceed, they could reauthorize this matter. Do you understand that, sir?
Yes, ma'am.
All right, thank you. This matter is dismissed. Have a good day, sir.
Thank you.
You too.
You too,
Sean,
Ms. Julian.
Thank you, you as well. Sean, you can leave the meeting. Thanks.
But they just threw that out.
Sean,
Yes, ma'am.
leave the meeting. You're still totally unmuted and you're on. So you need to click leave the meeting. Do you know how to leave a meeting? It looks frozen. There we go. All right. Thank you very much, Judge Washington. Have a nice afternoon.
Thank you, you too.
Thank you.
Christopher Johnson, yes. I don't see Mr. Johnson on or anyone else on. And with respect to this matter, do you want to take the file back over there? Is that what we're doing? Okay, thank you. I'll stay over here in the event that you need me. I'll stay here for a few more minutes in the event you want to come back. Thank you.